Welcome to the Wills and Estate Transmission Podcast, brought to you by Groots, specialist lawyers in wills and estates.
Hi, and welcome to the Wills and Estates Podcast with Groots. That's from degroots.com.au. And today we have John de Groot. How are you, John?
Very well, thanks, Tony.
And we have Rachel Ryan.
Hi,
Hello,
Tony.
Rachel. Okay, so we have John to introduce us today's podcast topic.
Yes, well, thanks, Tony. Today we're talking about enduring powers of attorney and why they're important in the estate planning sort of suite of documents, perhaps, that people should make sure they have one of, so to speak. An enduring power of attorney is one that is specifically focused on ensuring that if a person loses capacity, that the empowerment of their attorney continues. It needed legislation to achieve that because under a normal power of attorney, if the principal, the person who gives the power, loses capacity, that's the end of the arrangement because they can no longer direct the attorney. But with an enduring power of attorney, it's actually very much the opposite in effect, that once you lose capacity is when these enduring documents come into play. So our view is that they require a lot of careful attention to be done well, unless your affairs are so simple that you don't need to give them a customised treatment. But there are quite a range of issues that Rachel and I, in our practices, in preparing these documents, have come across and have required to put into these enduring documents. So I thought I might just ask Rachel if you'd like to kick off with some of the things that we have come across, and I can chime in as well.
Yeah, well, I guess the thing with enduring powers of attorney, the fact that, they continue to apply after someone's lost capacity, I guess the first thing that requires very careful consideration is making sure that you've appointed people that you trust, who will step into your shoes essentially and be making decisions for you at a time when you can't, and also that they've got the sort of skills that might be needed to deal with the sorts of things that form part of your affairs. Then from there, looking at making sure that you identify, specific areas where the attorney might need to have some guidance and direction about what it is that you do want them to do on your behalf. One very common area that comes up probably for most of our estate planning clients, most people have a pet, at least one pet, we find, and pets are, part of the family. They're very dear to clients, and without realising, if you don't have arrangements in place for the care of pets, an attorney is not necessarily going to be able to carry on providing the level of care for the pet that you would necessarily want them to ensure happens, the sort of, the level of care that you yourself provide, unless you give some specific instructions to the attorney about that, and also give them some specific authority to use your funds to pay for the pet's care at the level that you would want them to.
Sometimes too, Rachel, people will go a further step and actually provide directions about what the pet likes to eat, what playmates they might have, what toys they have, a whole lot of personal aspects of the life of a pet that are very helpful to be recorded. So that's another dimension. It's straying a little bit out of the direct authority of the attorney, but nonetheless they're part of what can be done to ensure that the care of the pet is completely sort of covered and guided and directed. I will mention a couple of other things that I know can be important. A lot of people who have the resources are very keen to stay in their own home if that's at all practical. And again, it's important to specifically direct and authorise the attorney to spend your money on home care. Now, that may mean that your home may need to be modified. There may need to be equipment purchased to facilitate the comfort of living at home rather than in an institutional environment. And it's important that a power of attorney is advised of that, and where the resources are there, that if it's at all practical and sensible, they want to be cared for at home.
Yeah, I think it's interesting actually in relation to that. So some clients are very adamant about wanting to be cared for at home, and they do have the resources there that can comfortably fund that. But even within that space where people do have abundant resources and could fund home care, they want that to be the arrangement that's facilitated if it's practical, but they want to stop short of it becoming burdensome on their family. So there isn't a one-size-fits-all approach to that. Some people want to live at home for as long as that's not going to cause issues for other family members, and then they would prefer that their attorney actually identify a quality nursing home environment for them if that's the stage that they've reached in life, that they really, can't continue to live at home without it impacting adversely on other family members. So it's a case of exploring with each client that territory and what they would ideally want to have occur.
One of the other areas that I think is always important is that you'll find that a lot of people are generous to those around them. It may be that they pay for the school fees of their grandchildren. They may support one of their children who, for a variety of reasons, may not be a good money earner for themselves or able to develop an estate that would look after them and so on. So you cannot, as you'd expect, give a person's money away as their attorney, except in very limited circumstances that the Act provides for. But if you specifically authorise and direct that certain loans or gifts that you've made traditionally, the principal, he can advise the attorney to say, well, look, I want these gifts to continue. Whatever I've done during my lifetime, I want them to continue. And often you can be quite specific about the gifts that you want made, as I said, about school fees for grandchildren and the like. So that's another important area to ask a client and say, do you do these sorts of things? Are there any particular people in your life that you support financially that you'd like to continue so that your attorney can comfortably continue with those arrangements?
Thinking in terms of probably the most generous provision that I personally have assisted a client to include in their enduring power of attorney, extended to instructing attorneys to spend up to a sum of, I think, approximately $2 million on purchasing a residence for a member of her family. She was planning to do that herself, and no doubt will achieve that. But when a client's sort of describing to you, well, this is what I'm planning to do over the next, 1 to 2 years, immediately that, the thought comes into our heads, well, that's great, but what if something happens to you in terms of your capacity in the meantime? Do you still want that to occur? And if so, we should make sure that your attorneys are given instructions about that so that your plans aren't thwarted by some unexpected loss of capacity in the meantime.
Talking about houses does remind me about the circumstance you sometimes come across, and that is that somebody is living in the home with the principal, with the person who gives the power, and they want that living arrangement of that person to continue. Sometimes it could be a family member, often perhaps a daughter or a son, who has decided that they'd move home to look after mum and dad, and we've had some unpleasant situations where the other siblings who've done very little for their parents suddenly resent the fact that they should be able to live there even if the parents are actually put into or go into a convalescent home environment. So that's another issue about homes where you can specifically say, I specifically authorise and direct that my daughter X continue to reside in the home during my lifetime, because on their passing, of course, their will provide what's going to happen. But that can be very significant provision that should be made.
Absolutely. And I think it's increasingly common that people have adult children living with them for longer than might have been the case in previous generations. I think housing affordability is impacting on that. So a lot of clients do have adult children still living at home with them and don't want it, a situation to arise where that would be disrupted because mum or dad loses capacity. So having all of that mapped out and the basis upon which they would want their child to be able to have that right to continue to reside in the home, what sort of contributions are expected from the child, what's to be funded out of mum and dad's assets, that sort of thing. So to get that clarity and customising of those arrangements. A lot of people assume that these things, they've been agreed, so why, that they don't understand that the ground shifts if someone loses capacity and then the attorney is standing in the shoes of the principal and has to make all of the decisions in the best interests of the principal. So that's where there can be a tension where the attorney hasn't been given specific instructions to continue on with arrangements that arguably aren't in the principal's best interests on the face of it, but are things that the principal, if asked, would definitely say, yes, I want that to continue, but it needs to be specifically authorised for that to be the case.
Yes, no, I very much agree with that, Rachel. Lifestyle requirements are also, we've already mentioned about, look, if they want to specify the home care environment, yes, or they want a convalescent home, and sometimes people will identify the convalescent home that they'd like to go to, particularly if they're keen on it must be an air-conditioned environment or whatever it may be. But you also have lifestyle issues. We've had cases where people say, look, I want to, even if I don't have capacity, I want to be able to drink my good wine collection. And that was one that we found quite interesting and but important to the person. And it's all sort of that another person, I think, wanted to be taken to the beach every week. So, and the costs of fulfilling that and so on. So the document has the opportunity to provide a lifestyle template as well as the practicalities of how my money's to be spent, because lifestyle costs money and the two go together and the two should be married. So I think that's important. You might like to talk, Rachel, about in the more sophisticated situations, sometimes not so sophisticated, but where there are loans owed to the principal and they can sometimes disrupt entities and so on. Would you just like to say a few words about that?
Yeah, I guess that's another example of the ground shifting where someone loses capacity. So if you've loaned money to someone, and often within families, there will be some significant loans between individuals, a parent to a child, for example, and it's on the basis that it's just repayable on demand. There's no sort of structured repayment plan. It's just sitting there. Having loaned the money, it's up to mum or dad to decide, if and when they might call for that money to be repaid. They're aware of the child's circumstances and there's a leniency there that's completely fine. But the ground shifts if that parent loses capacity and the attorney is then standing in their shoes and is charged with that obligation to make sure that everything they do on behalf of the principal is in the principal's best interest. So, of course, the attorney, is prima facie obliged to make sure that any monies owing to the principal are drawn in back into that pool of assets that can be applied for the principal's benefit. So if there is a loan arrangement, it's very, very useful to explore with a client whether they would want the attorney to be able to continue to just allow that money to sit out there and not be obligated to call it in on behalf of the principal if they lose capacity. That could be a loan to another individual. It could be a loan to a family trust or some other related entity. And it can cause a bit of havoc, actually, in terms of the liquidity of a trust if there's a loss of capacity suddenly necessitates that significant loan account is pulled back into the personal estate of the principal. So it's very useful to give the attorney the ability to have some flexibility there that it's not absolutely incumbent upon them to make sure that money is pulled back in, that they have that flexibility to just let it remain unpaid from the trust.
Yes, like sometimes they may say, look, unless the monies are required to support my maintenance and well-being, they're quite happy for them to continue to be interest-free repayable on demand. But as you've said, and I agree, every case is different, and I hope from what we've said today that our listeners will appreciate that there are many, many issues that they should thoughtfully consider when they're making an enduring power of attorney, and make sure that it does lock around what their life is all about, what their family's all about, what their affairs are all about. Very, very important customising that should always go.
I think just back to the topic of gifting as well, some of the gifting that's authorised in the enduring power of attorney documents that we prepare for our clients is very integral to their overall estate plan. Just expanding on what we mentioned earlier, John, in relation to gifting that the principal might want to specifically authorise in their enduring power of attorney document, there are certain gifting arrangements that are actually integral to the overall estate plan that a client is wanting to achieve, where there might be some serious concerns about their personal estate being challenged, whether that's by a family provision applicant or in some other way. There's a desire there strategically to make sure that the size of their personal estate at the point that they pass away or prior to the point of them passing away is minimised. So some of the gifting that we've assisted clients to specifically authorise and direct their attorneys to undertake might, for example, relate to in tandem with instructions to withdraw their superannuation entitlements on their behalf prior to them passing away, to then immediately gift a significant portion or perhaps all of those superannuation entitlements in some cases from their personal estate immediately into a discretionary family trust, that sort of thing. So it's not always tied to largesse and generosity. It might be more motivated by an overall strategic arrangement of their ownership of assets that relates to wanting to minimise disputes post-death.
Well, I hope that what we've talked about as necessary to ensure that your enduring power of attorney does what it should do for you personally, we've given you not an exhaustive lot of arrangements, and I suppose that's always impossible in these situations, but nonetheless gives you a bit of a flavour for the important issues that at least we've encountered for the benefit of clients to put in enduring powers of attorney. I mean, just a quick run through, we've talked about pets, care of yourself at home, gifting arrangements and support of grandchildren for education and those sorts of things. We've talked about lifestyle issues. We've talked about living arrangements with a family who might be living with you to help you get by until the time comes when it's appropriate for you to be in a convalescent home environment, all those sorts of things. So I hope our listeners have got a bit of a flavour for things and that it's given them food for thought, and when they do their enduring power of attorney, they'll be expecting that those issues will be addressed in it.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.